I am Kumari, working as lecturer in PS Rasula College, Kakinada, affiliated to Nalaya University, Rajamahendravaram. Teaching CPC subject. Today's topic is the principles res judicata, the subjudies. Actually, the disputed matter can be taken before the court of law for the final justice and for the conclusive justice. Actually, the disputed matter is treated as a suit. The parties may bring the suit or bring the disputed matter, whatever the transaction held in between them. Actually, suit must require two parties and the subject matter, and actually what is the cause of action aroused. The jurisdiction can be decided by the worth of the suit and according to the nature of the suit. First suppose, if it is a matrimonial matter or if it is a family matter, it can be taken before the court of law for the final justice and the suit can be filed. If it is a divorce matter where the parties are lost decided or where the cause of action is aroused. Actually, the court can follow the principles and the court must maintain the principles of res subjudies and res judicata. What is res subjudies and what is res judicata? Actually, section 10 of CPC defines res subjudies and section 11 defines res subjudicata. What is res subjudies? Actually, if any disputed matter directly or substantially in the court of law, pending before the court of law, between the same parties on the same cause of action, no new litigation can be maintained anywhere in India. It means if two parties are maintaining a suit and the decision is not delivered by the court of law and the final justice is not declared and it is pending before the court of law directly or substantially, the same parties on the same cause of action, they have no authority or they have no right to take that matter anywhere in India or challenge the matter anywhere in India. This is defined in section 10 of CPC as res subjudies. Actually, what the suit requires, two parties are needed to be a suit and the suit may be transferred from one court to another court by a competent court jurisdiction. If it is the matter of the district court, the High Court can transfer from one court to another court on the grounds of principles of natural justice. And actually, res subjudies can be maintained between the same parties and the same cause of action. If it is pending before the court of law, anywhere it cannot be challenged. And what actually res judicata is? So res subjudicata it is if the same parties on the same cause of action, if one court, the competent court delivered the judgment or it is declared the judgment, the same parties on the same cause of action, they have no authority to challenge anywhere in India. It means if once a competent court delivers the decision or it declares the judgment, the same parties on the same cause of action, they have no right or they have no authority to take the matter before any court or in the same court for the justice again. It means actually CPC's aim is to shorten the litigation and the court mainly objects or the court mainly concerns to shorten the litigation and to reduce the expenditure. And actually should not allow to go against the good conscience and it should not allow to hang the sword of uncertainty on the litigant's rights. Actually, res subjudicata. This res subjudicata is maintained between the same parties and the same cause of action. If the court delivered the judgment, the parties has no authority to challenge anywhere or in the same court because the competent court has the authority to declare the judgment and it is final and conclusive to that court. Actually, the decree, what it means, decree is nothing but a formal expression of the court and it is final and conclusive to the competent court and that court can declare that as a final one. The object of CPC is also to give the final justice or to give the final conclusiveness. Actually, once the judgment is delivered, it is conclusivity and it is final to that court of law. And actually, section 11 does not allow or does not affect the justice but operates as a part of trial. Justice is it operates as a part of trial. Res judicata tries to strike a balance between separate pleas. One asserts an efficient judicial system which reduces and which gives the final judgment, and it gives the certainty and it prevents the inequality between the parties or second priya. And actually one judgment is there by Supreme Court in Ghulam Abbas versus State of UP. The scope of res judicata is well decided. It does not create any rights or any interest over the property but operates as a bar to try the issue once again. It means if the judgment is delivered by the court of law and if the judgment is declared, it should not allow a second plea or it should not allow a second suit in the same court on the same cause of action and between the same parties. Actually, it works. What are the ingredients and how the principle of res judicata works? The first principle is the identity of the parties, and the second principle is the identity of matter in issue, and the matter must be directly or substantially delivered. And identity of the parties is very important. And on the same cause of action, the second suit or the suit cannot be maintained in the same court jurisdiction because it is finally decided by a competent court and the parties are not permitted to reopen it in a subsequent litigation in the same court. Actually, it requires there must be a final judgment and the judgment must be given on the merits and the claim must be the same. It means if the claim is the same claim and the parties are claiming for the same relief in the same court, the court should not allow to maintain that. But the principle is having some exceptions. It means if it is a maintenance order, the principle of res judicata cannot be worked. And again, in some constitutional matters, the principle of res judicata cannot be worked because the court can overrule its decision and the court can give the same decision or reiterate or it can overrule the decision. For example, reservation cases. Actually, in Balaji versus State of Madras, the Supreme Court delivered a decision reservation should not be exceeded 50%. But it was overruled in Indra Sahni's case. Again, this decision is also overruled in another case. It means the principle of res judicata should not be operated or it should not work in some constitutional cases and in cases of the family matters just for maintenance order, etc. Actually, res judicata, this principle is based on the principles of natural justice and the main concept of this is to shorten the litigation and not to entertain the litigation on the same subject matter. Res judicata is explained under section 11 of CPC and actually section 11 says between the same parties on the same cause of action for the same claim or for the same relief, no second suit or no new suit can be entertained by the same court of law. This is the principle explained under section 11. But res subjudies, it defined under section 10, it means directly or substantially if any suit is pending before the court of law, the court should not allow new litigation between the same parties on the same cause of action. And actually, section 30 defines what is foreign judgment. Actually, section 13 of CPC explains the foreign judgment. Foreign judgment, it is nothing but given by the judgment given by the foreign courts. And the court gives the judgment or the court which is situated outside India, if it delivers the judgment, it is called as the foreign judgment. Actually, the foreign judgment means adjudication by a foreign court. It enforces in the principles of competency. It means competent court adjudicate the claim. The circumstances which would give jurisdiction or the person is the subject of foreign country and he is a resident when the claim was filed before the court of law. Plaintiff's selection of a foreign courts and the plaintiff voluntarily appeared on summons and again the party should not be binded and not pronounced by the judgment is not pronounced by competent court and the judgment is against the principles of natural justice and the judgment is given not on the merits of the case and the judgment is against international law or Indian law obtained and the judgment is obtained by fraud and if any breach of law is there and the judgment is delivered on breach in these circumstances, the foreign judgment can be challenged. Actually, what is the judgment given by the foreign courts? That it can be called as the foreign judgment, and the judgment must be given by a foreign court, competent foreign court. If the judgment is given or by breaking of law or against the principles of natural justice, or it is obtained by fraud, and the plaintiff he voluntarily accepts for the judgment, and it is not given by a competent court jurisdiction. In these circumstances, the judgment can be challenged.